Welcome back to Church in the World. This is part 3 of our discussion of the ELCA's social statement on criminal justice, hearing their cries. This statement, we've talked about first the state of the criminal justice system and why it is that it's so important to address it in something as expansive as a social statement for the ELCA. We talked about the theological call of the church and the church's understanding of the nature of a justice system and civil ordinances in general, and why it is that what standards it is that we apply. And that was last video. And this video, we're going to talk about positive emerging trends in the criminal justice system, things we want to encourage, the ending of the overuse of incarceration in the criminal justice system, something we advocate for, and supporting needed reforms in the criminal justice system, addressing racial disparities, ending discrimination, recognizing the needs of youth offenders, ending private prisons, and fostering reintegration of ex-offenders. So all of that is going to be talked about today. So we're moving from what the church is going to do to what the church is calling for in this particular situation with some specifics. Again, these are broad reforms, and the reason why is because the church is not trying to write policy, but the church is trying to negotiate and identify policy goals, as say things to which we want policy to aim, right? So that's what we're doing here. This is not writing laws or policy, but it is saying these are things that we need to be doing as a society. So let's get into it. Here we go. So this is on page 31 if you're following along. The link is in the description below to this statement as well as the other statement that will begin tomorrow. But this is part 5, page 31, Paths to Greater Justice. Here are some positive trends. Despite deep and abiding problems in the criminal justice system, it is important to acknowledge positive trends that have emerged in recent years. The ELCA supports trends such as greater emphasis on victims' rights and needs, use of restorative justice, community-based alternatives to incarceration, legislation that reduces sentences for certain offenses, the emergence of specialized courts, and the growing emphasis on re-entry programming. So we're going to do a brief overview of this just so we can make sure that all those things are understood. Victims' rights. These are things like the right to fair treatment, dignity, and respect, the right to be informed about court proceedings and victim services and rights, the right to be present at legal proceedings, the right to a voice at a sentencing and at proceedings involving offender release, and the right to restitution from the offender. Now, a whole bunch of states have passed that, and we want to encourage that, we think, but more still needs to be done to develop victim sensitive practices. Okay, so we advocate for all of those things. Next, restorative justice. This is something that focuses on crime as an offense against human individuals and the community, rather than a crime being an offense against the state. While not denying the state's role or appropriate place of retribution, this approach, restorative justice, encourages victims to take an active role in responding to crime and invites offenders to take personal responsibility. Restorative approaches seek to bring together the victim, the offender, and other members of the community harmed by that crime to develop a plan to try to repair the harm. So there's some discussion about the strategy. In its attention to people involved, it provides a fuller account of the nature of justice and creative alternatives to incarceration. We note that congregations could consider becoming host sites for restorative training and programs. Likewise, individuals are encouraged to consider participating in restorative practices by becoming trained facilitators, community participants, and advocates in both diversion programs and correctional facilities. Okay. What else? Alternatives to incarceration. Since the year 2000, many states have expanded their use of community-based corrections for offenders who do not pose great danger to society. This especially includes drug offenders. These alternatives include intermediate sanctions such as home confinement, electronic monitoring, halfway houses, residential work release centers, day reporting centers, intensive probation supervision, and treatment and diversion programs for drug offenders. All of these should be encouraged and funded. In recent years, community-based alternatives have also been used more extensively in some states to reduce the number of probation and parole revocations that result in incarceration. Several states have decreased prison populations by enhancing parole consideration for incarcerated individuals. Some parole agencies have developed graduated sanctions as alternatives to incarceration for parole violations. Alternatives to pretrial incarceration can reduce stress on jails, and the use of alternative forms of pretrial release on both federal and state levels have been promising. The goal is to put in place pretrial supervision as well as evidence-based assessments for determining conditions of release. We want to encourage sentencing reform. Since 2004, more than 20 states have enacted or proposed legislation to reform sentencing policies. These changes have focused on several types of reform. Primary attention has been given to increasing sentencing options that divert drug offenders from incarceration to community-based treatment alternatives and expanding sentencing alternatives to incarceration for other nonviolent offenders. Other reforms have attempted to increase use of community supervision and technological innovations, such as electronic monitoring to respond to probation and parole officers. Some states have established or expanded programs that divert to drug treatment those who commit certain drug offenses. Others have authorized early release from prison to community-based housing and treatment programs for offenders who meet certain criteria. These reforms often are encouraged solely on the basis of economic cost. Improvement for any reason is important to the individuals involved, and the burden of a cost is a necessary factor for the government to evaluate. But changes made simply for economic reasons are less likely to endure, and people of faith also must evaluate practices in terms of moral justification, that is, whether the people involved are harmed or aided. We advocate for specialized courts. In recent decades, specialized problem-solving courts have developed for those with drug-related mental health problems as well as for veterans. Through successful participation in treatment programs, defendants are able to avoid traditional court sanctions such as jail time. Drug courts in particular have been used with success. It's notable that about half of state and federal prisoners meet criteria for drug dependence or abuse. In drug courts, judges, defense attorneys, prosecutors, treatment service staff, and community correction staff generally work together to address cases. Case management typically includes risk and needs assessment, intensive monitoring, graduated sanctions and incentives, and treatment and other rehabilitative services. Though intensive monitoring and services are initially costly, in the long run, drug courts are cost-effective when one considers the reduced recidivism of drug court participants. Mental health courts and veterans treatment courts are less widely used and are underfunded, but are similar in their rehabilitative focus. Like drug courts, the potential impact of mental health courts is significant. Research indicates that approximately 65% of jail inmates and about half of state and federal inmates have mental health problems. Female inmates are significantly more likely than male to experience mental health problems, and the female jail inmates have significantly higher rates of serious mental illness compared to males. Outcome evaluations are still limited, but early evidence hints at effectiveness in reducing arrests and jail time. And veterans treatment courts focus specifically on mental health and substance abuse issues for military veterans who have committed criminal offenses. These issues often result from psychological stresses of combat that are not adequately addressed when military personnel return home, almost like we don't care about them. And then we want to encourage reentry programming. Since the late 90s, there has been a greater emphasis on the reentry process and recognition that transitional services are essential to successful reintegration into the community following incarceration. Governments are encouraged by this church to continue funding expansion of individualized reentry plans and to provide a range of services through coordinated efforts with community agencies. So those are all things that we think need more emphasis, encouragement, and examination. Those are positive trends in criminal justice. Great. Now let's talk about ending the overuse of incarceration. And we're going to talk about 1, alternatives, 2, reforming of sentencing, and 3, scrutinizing national drug policy. Why are we talking about this in specific? The society must find ways to end the overuse of incarceration. As mentioned earlier several times in previous videos, compared with other countries along any relevant scale, the U.S. overuses incarceration as a response to criminality. Because of the significant harms, both personal and social, caused by incarceration, we strongly urge those who make and administer correctional policies to take all appropriate measures to limit the use of incarceration as a sanction for criminal offenses. To achieve this goal, we identify these three specific objectives. Aggressively pursue alternatives to incarceration, reform sentencing laws and policies, and closely scrutinize national drug policy. Okay. What are some alternatives to incarceration that we can pursue? Well, we urge greatly expanded use of alternatives to incarceration, such as those commended above in positive trends, right? This includes community-based alternatives to incarceration for convicted offenders and for those who violate conditions of probation or parole, for juvenile offenders, for those detained because of immigration status. We also support more treatment-focused alternatives to the use of jails and prisons for mentally ill offenders. In particular, we encourage greater use of pretrial release programs for individuals held in jail while awaiting trial. At mid-year 2010, 11 years ago now, nearly 749,000 individuals were confined in local jails, mostly for relatively minor, nonviolent offenses. Of these inmates, 61% had not been convicted but were detained awaiting trial or other court proceedings. While some were denied the opportunity to post bail as a danger to the community or a risk for non-appearance in court, most were not. By one estimate, $9 billion are spent annually to incarcerate individuals awaiting trial who cannot afford bail but pose little threat to society. Holding people in custody significantly disrupts people's lives and can result in the loss of work, home, and property. Incarceration while awaiting trial increases the likelihood of conviction, and stiffer sentences can lead to the loss of income for families. A racial and ethnic component is also evident, given that people of color are disproportionately likely to live in poverty and therefore are less likely than Caucasians to be financially able to post bail. Right? So all of that, right, is important. But specifically and first and foremost, we can definitely figure out something better about pretrial alternatives. We can certainly start with that. Reform sentencing laws and policies. Numerous sentencing policies have been adopted since the 1980s. I wonder what happened in the 1980s, including mandatory minimum sentences, habitual offender laws, truth in sentencing laws, and sentencing guidelines. Their implementation has led to increases in the use of incarceration and in the length of sentences, and has limited judicial discretion in the sentencing process. Habitual offender or three-strike laws, for example, impose lengthy sentences on chronic offenders. Nearly half of the states have them, and in some, the law has applied even if the third felony conviction was not for a serious or violent offense. Mandatory minimum sentences that impose lengthy fixed punishments on offenders and prohibit judges from considering mitigating factors have been used most extensively in response to drug-related offenses. In addition, sentences have been lengthened through truth in sentencing laws, which target serious violent offenders and require those convicted to serve at least 85% of their sentences. Such laws exist at the federal level and in more than half the states. We call for review and legislative reform of these sentencing policies for three reasons. First, researchers have raised serious doubts about the effectiveness of more severe sentences in deterring crime. Second, the policies shift discretion from the judge's sentencing decisions to prosecutors' charging decisions, which are less susceptible to public scrutiny and therefore likely to be inconsistently applied. And third and finally, these policies exact enormous and unnecessary personal costs on offenders, families, and neighborhoods, along with a massive demand for public resources when tax dollars are desperately needed elsewhere. See the economic justice statement, see the healthcare statement, see the education statement. Lengthy sentences are produced by these policies and mean that offenders are incarcerated long beyond the point at which they would likely have aged out of crime and ceased to pose a threat to society. And finally, as part of ending overuse of incarceration, scrutinize the national drug policy. Any comprehensive assessment of the criminal justice system must attend to national drug policy because that policy has a marked effect on all aspects of the system. In particular, the national drug policy bears significant responsibility for the dramatic increase in the incarcerated population. In 2010, 52% of federal inmates and 17% of state prison inmates were incarcerated for drug offenses. As noted above, mandatory minimum sentences have been used extensively for drug-related crimes and have led to exceptionally long periods of incarceration. Regardless of what future directions U.S. national drug policy takes, this church raises grave concerns about aspects of this present approach. First, the image of a war on drugs reinforces a movement towards more militarized policing. Sound familiar? Although special circumstances of extraordinary threats sometimes may justify the use of military-like tactics and equipment, these circumstances should not be treated as the norm and run counter to proven community-based methods. Second, the national drug policy has directed substantial resources toward one very specific form of criminal activity. Drug abuse can be devastating for individuals and communities, and the international trade in illegal drugs continues to cause political conflict and instability in many countries. The intense focus and expenditure on drug crimes, however, may come at the expense of other public needs, both within and outside the criminal justice system. Some of the significant resources spent on law enforcement efforts could be devoted to drug treatment and drug use prevention efforts. Further, current law allows law enforcement agencies to seize and retain assets used in or gained from crime. This power may create an improper financial incentive for law enforcement, especially given the relatively sparse judicial oversight of asset forfeitures. Third, and finally, there is mounting and pervasive and persuasive evidence that the war on drugs has had a disproportionate impact on people living in poverty and people of color. If this is news to you, I don't know where you've been, honestly, but I can vouch for this. Law enforcement practices regarding drug offenses often have targeted disadvantaged communities, and the sentencing policies regarding drug crimes have had racially disparate effects. Despite the fact that Caucasians and African Americans engage in drug offenses, both possessions and distribution, at similar rates, Black people have been far more likely than white people to be arrested for drug offenses. Policing decisions about which neighborhoods and types of drugs should be the focus of enforcement efforts only contribute to these disparities. Federal sentencing policies regarding cocaine offenses offers a stark example of the racially disparate impact of overall drug policy. Although the tremendous disparity in sentence length for powder versus crack cocaine offenses have been diminished in recent years, it still exists. Despite broad consensus that national drug policy has been marked by improper use of war language, very high costs, and disproportionate burdens on vulnerable members of our community, there are widely divergent views about the proper response. Some argue for decriminalizing the use of illegal drugs and a shift towards a public health model for addressing the negative effects of drug addiction and abuse. Others contend some measure of criminal prohibition remains necessary to secure both individual and social well-being. We do not presume to resolve that debate. In fact, I would say that debate is probably a false dichotomy on its face, at least in terms of the short-term policy goals. But we do call for close scrutiny to the full costs and consequences of drug policy. These costs include the resources required to implement the policy, as well as the costs to those who are harmed by the policies. There are histories behind the designation of unlawful substances. Human decisions have made some substances illegal while permitting others, and have made some substances legal in some jurisdictions or in certain time periods. The histories behind the construction of drug policy point to the role of contextual factors, including the race and class of those who use particular substances. Those histories should be considered when revisiting these policies' harmful effects. A responsible society must question whether the policy's benefits are sufficient to offset those costs. Finally, we need to support needed reforms. Although the problem of mass incarceration demands immediate attention, we highlight 4 other imperatives that require prompt and vigorous response from those who make and implement criminal justice policy. While each deserves attention for its own sake, reforms in these areas will also reduce the incarcerated population significantly. First, the criminal justice system must acknowledge the racial disparities and address the implicit and explicit racism that persists there. Remember when I mentioned George Floyd in the first video? You might have wondered why, because I didn't talk that much about racism. Oh, look, here it is, specifically saying this. In fact, I'm going to read it again. Here's a reform that we think absolutely needs attention. First, the criminal justice system must acknowledge the racial disparities and address the implicit and explicit racism that persists there. Got it? Second, the criminal justice system must recognize the special needs of juvenile offenders. Third, it must stop the privatization of prison facilities. And fourth, it must foster the full reintegration of ex-offenders into community. Okay, let's start with the first. The criminal justice system must acknowledge racial disparities and end discrimination. The estimated prison population under state and federal jurisdiction at year-end 2011 was 34% Caucasian, 38% African American, and 23% Hispanic. Yet, non-Hispanic Caucasians currently make up 63% of the U.S. population. African Americans make up 12%, and Hispanics make up 17%. Percentages are greatly disproportionate for other peoples of color also, such as American Indians or Alaska Natives. Racial disparities appear in juvenile justice systems as well, including disproportionate minority contact with juvenile justice systems. Some argue that these numbers represent the disproportionate involvement of people of color in crime. Sound familiar? African Americans, for example, have high rates of involvement in crimes such as homicide and robbery that are punished by incarceration. Yet, even when these high rates are taken into consideration, significant disparities persist, and research shows that race influences decision-making at numerous points in ways that disadvantage people of color, e.g., policing decisions regarding arrest, prosecutorial decisions regarding charging, and judicial decisions regarding bail and sentencing. Clearly, the cumulative effects of these decisions contribute significantly to racial disparity in incarceration, and the United States society has a history of and continues to manifest racism and profound economic inequality. We believe actions must be taken to end racial disparity in practices within the adult criminal and juvenile justice systems and to address the issue of racial disparity. For example, we express grave objections to patterns of racial, ethnic, and religious profiling. Although some police departments have adopted robust policies to counter the problem of racial bias, discrimination remains and carries many harmful consequences. Profiling, whether intentional or unintentional, stigmatizes those who are innocent of any offense. It alienates members of the public who come to view the justice system as antagonistic rather than as a safeguard to all people's rights and property. Extensive efforts must continue until discriminatory profiling ends. Strong enough language for you? The rest of this should be a little bit more obvious and, to my knowledge, is a little less controversial, but we'll drift through it a bit. The criminal justice system must recognize the special needs of youth offenders. The juvenile justice system grew out of a social reform movement more than a century ago, based on the principle that youth are different from adults. They are still developing capacities for moral judgment. They may be less culpable and more amenable to rehabilitation than adults who commit the same offense. This principle, now supported by a significant body of research showing that brain development is still incomplete at age 18, which is interesting because it's not complete at age 22 either, but never mind, led to the creation of a separate juvenile system that aspired to be more rehabilitative than punitive. But in recent decades, juvenile justice has drifted from that initial impetus. The drift has been motivated by perceptions of rising violent juvenile crime and perceived shortcomings in the rehabilitative focus of juvenile systems. I wonder where that's coming from. Increasingly, the juvenile system has mirrored harsher trends in the adult system. Community-based alternatives for at-risk youth as well as nonviolent youth offenders remain inadequate in many communities. Large residential juvenile correctional facilities resembling adult prisons still abound and are often unsafe and ineffective. They demonstrate high recidivism rates and poor educational outcomes, and youth rarely leave prepared to succeed as adults. By the 1990s, nearly all states had expanded their policies regulating transfer of juvenile offenders to the adult system, permitting transfer at younger ages and for more offenses, almost like they're creating some sort of pipeline to ensure a certain amount of inmates. I wonder why that might be. States justified this expansion both as a means of more securely segregating violent or repeat juvenile offenders and as a means of better directing scarce funding in the juvenile system toward youth who are perceived to be most amenable to successful rehabilitation. Concerns about security and efficiency are understandable. It is undeniable that society deserves protection from youth who commit horrific crimes, yet the weakened distinction between juvenile and adult corrections has done great harm. Juveniles who are prosecuted or sentenced as adults are ill-prepared for the fundamentally adversarial environment of the adult judicial process. Very little allowance is made for youth's immaturity, lack of experience, or questionable ability even to understand their rights. Youth sentenced to adult prison compared to their peers in the juvenile system suffer higher rates of physical abuse, sexual abuse, and suicide. They are rarely provided age-appropriate educational or rehabilitative assistance. Female youth face special challenges when placed in adult correctional settings. Some might see these problems as tragic consequences of otherwise prudent correctional policies for juvenile offenders, But the policies themselves fail to promote safe communities. Most experts agree that laws encouraging the transfer of juvenile offenders to the adult system do not deter serious juvenile crime. In fact, there is compelling evidence that transferred juveniles are more likely to offend in the future than their peers in the juvenile system. Even youth who receive a sentence of probation from adult criminal court reoffend more often than their peers in the juvenile system. Transfer practices also magnify the racial disparity in our nation's justice system. You thought we were done with this. We're not. While black youth represent 17% of the overall youth population, they make up 62% of those tried in adult court. They are 9 times more likely than white youth to be sentenced to adult prison. Latino and Native youth are also transferred to the adult system and incarcerated in adult prisons at higher rates than white youth. We support an end to the current practices of trying, sentencing, and incarcerating youth in the adult criminal justice system, as well as ending youth sentences of life in prison without the possibility of parole. Recent Supreme Court actions reflect encouraging developments in rulings against the death penalty for those who committed their crimes as juveniles and against mandatory life sentences without parole. While advocating an end to current transfer practices, this church recognizes that some juvenile offenders pose significant risks to public safety and may not be appropriate for release upon reaching the age at which juvenile custody would cease. Reasons for include insufficient progress in rehabilitation or the severely grievous nature of their offenses. We are urging authorities to explore means of ensuring public safety without continuing the practice of transferring juvenile offenders to the adult system. Even these youth deserve initial secure placement within the juvenile system where they have every opportunity to benefit from rehabilitative and educational activities with their peers. Adult incarceration should take place only after completion of placement in the juvenile system and should be reserved for youths who have committed the most grievous offenses. The determination that a youth poses continuing high risk to public safety requires thorough objective assessment of risks and needs. The ELCA recognizes that the goal of keeping juveniles out of the adult criminal system requires the development and expansion of alternative correctional strategies. Some states have redefined the age at which adulthood begins, allowing youth to remain in the juvenile system beyond 18 and affording them maximum opportunity to benefit from rehabilitative efforts in the juvenile system. Some jurisdictions have seen promise in blended sentencing strategies which allow juvenile and adult sentences to be imposed simultaneously. The adult sentence is typically suspended but held as a possibility in order to protect public safety. At the most fundamental level, we call for a juvenile justice system that more closely matches its original rehabilitative intent and is equipped to meet the needs and manage the risks of all youth offenders. Promising initiatives for at-risk and first-time and nonviolent youth offenders include evidence-based therapeutic approaches for strengthening families, as well as community supervision initiatives. Such initiatives include after-school programs and evening reporting centers that constructively engage juveniles during peak crime hours. For youth who have committed more serious offenses and require secure residential placement, some jurisdictions have developed approaches demonstrating that even many serious youth offenders are amenable to rehabilitation. In a positive trend, some states are working to reform their juvenile systems by embracing these approaches. Until every state can meet the needs and manage the risks of all youth offenders within a rehabilitation-focused juvenile system, juvenile justice reform will be incomplete. We call upon members, congregations, social ministry organizations, and others to take part in building new social momentum for reforming juvenile corrections practices and treating youth as youth. Okay, we're only halfway through the needed reforms. End prison privatization, period. Okay, no? You want to hear a little bit about it? Fine, I'll do a little bit. Arguments used in favor of for-profit prisons, and that's, by the way, what they are. Private prisons get profit from being prisons, to be clear. They make money, or rather their owners make money off of their existence. Arguments used in favor of for-profit prisons cite their supposed cost effectiveness, their ability to reduce overcrowding in public prisons, and the introduction of free market competition to lower incarceration costs overall. Recent decades have witnessed a dramatic trend towards the usage and spread of private four-person prisons. But the arguments against them are much stronger, and for this church include concerns that are theological, moral, and economic. Theologically speaking, it is the role of government to restrain evil, not that of the market. Civil governments may be legitimately deputizing private companies to act on their behalf in some cases. Private entities, including many church-related organizations, have effectively and appropriately participated in corrections programs such as halfway houses. But such community facilities differ significantly from prisons. Such efforts must be carefully monitored when private entities are entrusted with even limited coercive power over individuals, where individual lives depend utterly upon the system, and as one comes closer and closer to matters of life and death, it is of utmost importance that the state not abdicate its responsibilities. When the state incarcerates someone as a prisoner, it brings upon itself special responsibilities for exercising custodial control. For this moral reason, the role of the state in the operation of prisons should not be supplanted by economic players who are guided primarily by profit or production. The profit motive of private prison corporations is apparent in reports to the Securities and Exchange Commission, where such corporations identify sentencing reform as an economic risk factor. Contracting with private firms for incarceration invites myriad offenses. Significantly, privatization works against rehabilitation and successful offender reintegration in society. When a corporation's profits depend on a steady flow of offenders into or back into its prisons, it is little incentive to try to rehabilitate those who are incarcerated. Studies have shown that cost-saving measures in private prisons have contributed to significantly reduced services for the incarcerated. These reductions in medical care, education, job training, and counseling thereby contribute to higher recidivism rates for those released from private prisons compared to public ones. Recent evidence also questions the supposed economic benefits of private prisons. Studies have suggested that cost savings are minimal or absent. In addition to reducing services for the incarcerated, efforts to cut costs have led to limited training of employees, relatively low pay rates among certain staff, and high turnover. Higher levels of violence are likely in such an environment. On the basis, then, of theological, moral, and economic reasons, we object to the current trends of corporate privatization in the criminal justice system. We urge government at every level to maintain or reclaim its responsibility and eliminate reliance on the use of private for-profit prisons. That clear enough for you? Finally, the criminal justice system must foster full reintegration of ex-offenders in rehabilitation, in reentry, in transitional support, and in occasional use of collateral sanctions when appropriate. The dominant aim of criminal justice is restored social order. Even the forms of punishment ultimately serve the goal of restoring a sense of social order. A balance must be achieved, therefore, between the harshness of punishment itself and the return of an offender to social life. If punishment is in some sense retributive, it must also be in some sense rehabilitative. For this reason, attention to offender services and the successful reintegration of ex-offenders to society matter as part of the criminal justice system. This church holds that social order and human flourishing will be enhanced by greater emphasis on rehabilitative opportunities for prisoners. Many enter prison with limited life skills, poor job histories, little education, and untreated drug or alcohol addictions. Upon their release from prison, however, they are expected to adjust to life back in their community if they have one, find work, support themselves, seek help for mental illness and substance abuse, and not return to crime. To dramatically increase chances for success, reentry support must begin long before release from prison. By identifying needs such as basic life skill and job skill training, education and treatment needs at sentencing, and then comprehensively addressing those needs during incarceration, the likelihood of successful transition back into the community is heightened. The religious dimension of life is significant and deserves to be a major component of rehabilitative programs for those who are interested. We also support improved programmings for released prisoners or those with alternative sentencing. The difficulties of finding housing, employment, and treatment, both for mental illness and addiction, make an offender or ex-offender's participation in society challenging. Think about how much your therapist costs you out of pocket with insurance. What is somebody just released from jail going to do? It's ridiculous. Sorry, it's a little off the cuff. Mentoring programs have shown especially encouraging signs of success in aiding released offenders. Congregations and social ministry organizations have found ways to act as mentors and supporters. The ELCA applauds and encourages such efforts. Yet the church must also remind the state of its duty to increase the possibility of successful reentry to society. The main responsibility lies finally with the offender, but impediments to successful reentry need to be removed to the greatest possible extent. Incentives for reentry preparation should be created. If inmates successfully complete prison programs related to post-prison success, sentence reductions may be appropriate. Support for rehabilitation and reentry programs alone is not sufficient. Current policies imposing punitive, long-term collateral sanctions also must be reformed for the sake of successful reentry and the reduction of recidivism. And when someone is convicted of a crime and a judge imposes the sentence, many invisible collateral sanctions are indirectly and silently added. These punishments are defined through legislation and restrict the rights of ex-offenders after their release. Such restrictions may include denial of the right to vote, restricted access to public housing, ineligibility for public assistance or educational loans, and barriers to employment for their entire lives, due both to employers' increased access to criminal records and to exclusion from particular occupations. The stigmatization of these restrictions harms people personally as much as some restrictions harm them financially. Beginning in the 1980s, the 1980s again. Why did the 1980s and 90s keep coming up? I wondered what was going on. Anyway, beginning in the 1980s, state legislatures and the U.S. Congress created legislation expanding the use of collateral sanctions. Examples include an increase in the number of states that permanently deny convicted felons the right to participate in the democratic process by voting. It is likely many U.S. citizens are unaware of the existence of such legal restrictions. This invisibility follows because, unlike prisons, those sanctions operate largely beyond public view and are imposed through law rather than by a judge in a visible courtroom setting. While some collateral sanctions are directly responsive to the risk posed by the ex-offender's prior conduct, the broader trend of collateral sanctions does not seem to arise from these concerns. Instead, the increased use of such significant consequences reflects the general shift towards more punitive responses to offenders and tough-on-crime strategies. This expansion has been politically popular, because unlike other forms of sanction, it has come at little cost to taxpayers. In that sense, there are political advantages to the use of invisible punishments. Such a narrow view ignores the consequences of these enduring punishments that significantly impact millions of Americans. For instance, there are real effects when a young man earns his GED in prison, but upon release is denied access to student loans for more education. The harms of collateral sanctions extend beyond those convicted of crimes to families and communities. In all cases, defendants and their counsel should be given more effective ways to determine collateral consequences and make plea decisions with full knowledge of those consequences. Although most collateral sanctions should be drastically limited, some are appropriate or even necessary when the sanction corresponds directly to the offense for which a person was convicted. It is reasonable to exclude those convicted of financial crimes from employment positions where they would have access to or responsibility for oversight of funds. Serious sex offenders and all child sex offenders should not have access to vulnerable individuals in employment or volunteer settings. The majority of invisible punishments, however, do not fit the criterion of necessity and therefore are unjust. We concur with the action of the American Bar Association that is called for restricting the reach of invisible punishment by limiting collateral sanctions to those that relate directly to the offense charged and prohibiting sanctions that without justification infringe on fundamental rights or frustrate a convicted person's chances of successfully reentering society. By the end of this video, which is near, my hope is that you have learned something new about the criminal justice system and about how deeply messed up it is. If you haven't, may I suggest the documentary 13th? It's, I believe, on Netflix. For a while it was on YouTube and may still be as well. I strongly recommend it as a history of the African American experience in particular with the criminal justice system post-slavery. Why post-slavery? What does that have to do with anything? Well, if you watch the documentary, you might find out. So, moved by all these cries and all these injustices, we are called to respond. Aware of the mounting evidence of the system's deep and abiding problems, we call for the adoption of these varieties of reforms. The leading concern is to decrease the incarcerated population, but other reforms delineated previously, we just went through them, are significant in their own right. At a deeper level, however, we recognize that a more fundamental transformation in thinking about criminal justice is required. We call for a transformed mindset that counteracts the logic equating more punitive measures with more just ones. That mindset challenges current undertones of vengeance, violence, and racism, and permits everyone in the criminal justice system to be seen as members of human communities created in the image of God and worthy of appropriate and compassionate response. We recognize that retreat from unduly harsh sentencing policies and overutilization of incarceration may be motivated by economic factors rather than by a moral critique of the way the system functions. Improvement for any reason is important to the individuals involved, but we maintain that responses to criminality should be made on theological, moral, and rational grounds as well. Changes made simply for economics are less likely to endure. Today, it is important to join with others of goodwill to challenge the flawed public consensus about crime and criminal justice. Until a shift occurs in the public consensus, criminal justice policies likely will persist that recognize neither the injustice nor the inefficiency in many of our current responses to crime. We place in God our hope for the fullness of shalom promised. Confident in the presence and promise yet to come of God's reign, we yearn for a greater measure of justice now. When reason identifies sites of injustice in these communities, institutions, and systems, compassion motivates our response. We appreciate the high ideals of the current criminal justice system, but at the same time, we have noted numerous issues about which it must be said that justice has not been done. Therefore, we recommit ourselves to ministry with, for, to, and among the many, many people whose voices cry out within our criminal justice system. As Micah 6:8 says, "What does the Lord require of you but to do justice and to love kindness and to walk humbly with your God?" So that's how the statement ends, on that powerful note. Why that powerful note? Because, to be perfectly frank, if it hasn't become blatantly obvious, what the ELCA says in this statement is our current American criminal justice system is infected by greed, racism, political convenience, and corruption, and is, to a large extent, completely hidden from those who do not have to directly interact with it. And none of that is acceptable. So what are we going to do, dear church? I'll let you think about that. We've suggested some reforms to advocate for. Think about, actually, here's an action item. Take those reforms and see if you can find them in the policy platforms of anyone you've voted for recently. Oh, and if you haven't voted recently, I think we've located one of the problems here, right? Because if Christians aren't voting, how are we going to be participants in the political process? Now remember that there's a large number of people who can't vote in this country. They've had that right stripped from them because of a crime. Think about that. They don't have the option to care about who they vote for. What does that say about us? And what does it say about Christians when we don't do anything about it? Thank you for joining me for this journey through the church and criminal justice, hearing their cries. We are moving on tomorrow to the statement of the ELCA in 2019. It's the most recent one and therefore the last one. And we'll have a 3-part video on the statement on the topic of sexism. See, you thought that you'd heard too much about racism. Now we really get to hear fun stuff. Something that's also been woven through this whole conversation. We heard a couple of vague comments about women's issues, the abortion statement. We heard about criminal offenders who are female, but now we're going to get into it. We're going to talk about sexism, and I look forward to this statement. It's fairly recent, so it's the least familiar to me, and I hope you'll join me for that tomorrow. Until then, God bless.